Welcome to this session of the Small Business 21st Century. I'm your host, Don Moraney, and we're going to have another Wealth Zone University today with a very important topic, and that important topic is intellectual property. I've got as my guest Fred Samuels. Fred is a partner with Kahn and Samuels, LLP. And Fred, welcome. Tell us all about yourself.
Thank you, Don. Well, I am, first of all, a local product of the DMV. Grew up in Silver Spring, Maryland. Went to college at Howard University and the University of Maryland, and went to law school at George Washington University. So all my education has been local, and started my law firm in 1997.
Okay.
And been practicing in the intellectual property field ever since.
Fantastic. Intellectual property. We talked about that at a prior segment about what it is, but just give us a quick intro about what types of things are intellectual property, just to refresh our memories.
Right. So intellectual property is basically things that are created in the mind, and inventions relate to the way products work, methods of using products. That's one form of intellectual property that tends to be protected by patents. Mm-hmm. We have expressions of ideas, which is the realm of copyright. And for example, that would be for written work, visual arts work, software code, sound recordings and music, and such. Those are considered expressions of ideas. Mm-hmm. And then we have trademarks, which are words or symbols, sounds, scents, and such that distinguish one product or service from another product or service. Mm-hmm. So those are the basic forms of intellectual property.
Okay, all right. One of the things that I want to talk about is, are there special concerns when it comes to government contracting companies owning and using intellectual property?
There are. Government contractors are subject to special ownership rules. Typically, and we're talking about federal contractors mm-hmm, in this case. Mm-hmm. The federal government, through the Code of Federal Regulations and some of the agency-specific codes, like the DFARS and the FAR mm-hmm, and such, mm-hmm. Regulate how intellectual property is owned when the government funds a project. Mm. So let's start with research and development contracts, which is where we find a lot of special rules.
Okay.
Typically, in a commercial world, the inventor who comes up with the new invention, let's say a COVID test, for example, mm-hmm. would own the intellectual property rights in that COVID test. Mm-hmm. Mm-hmm. But if the government lets a contract to a company to develop a COVID test, that test is owned, the patent rights are owned by the commercial company, but the government has a very important license right. In other words, they have a right to use that technology and have it made for them. Well, what does that mean? Mm-hmm. That means that even though the company received the contract to develop the test, they may not receive the contract to supply the test to the government. And it's that contract that they really want because it's more lucrative, the mm-hmm. supply contract mm-hmm. than the development contract, mm-hmm. because the government gets all the intellectual property rights in what's developed, and they can then go out and competitively bid the supply contract. And so that's an important notion. And So
before we leave that, let me make sure I understand. My company has a contract to develop something for the government. And let's just say I'm one person company. I develop it.
Yes, sir.
I have certain rights, but the government also has certain rights to that same product because I made it for them?
Because you made it with their money.
With their money.
It's all about the color of money in the government.
Okay.
And so if you use the research dollars that they gave you mm-hmm. to do this research and develop this product, mm-hmm. then they acquire the rights. they acquire a right to use it.
To use it.
They don't own it.
Okay.
So in other words, you can go out into the commercial space, and other people in the commercial space can't use that technology.
Right. Okay.
But oftentimes, government contractors don't play in dual spaces. They only play in the federal space.
Right.
And so it's important to know that once it's developed, then the government can competitively bid it. So you won't necessarily get the supply contract.
So let me ask, if I develop it, do I have the trademark or patent on it?
Right. So in the example that I gave,
Yes.
we're talking about a COVID test, and that's something that you would protect by patent. Now, if it's a good question, because if you came up with a unique name for that test, Don's test, and the government does not get the trademark right. The trademark right may or may not be as important in a government sale context, because the government is having the test made for their purposes, possibly. Like maybe they're doing it for the Army and they're giving it to the enlisted people. So branding isn't as important there, but it could be if the recipients don't trust. They only trust the test by that name, right? But in the government space, they don't get the trademark rights in the same way they get the patent rights. What they're most concerned with, what the government is most concerned with, is that they feel they've paid to develop it. They shouldn't pay a premium again when they want to buy it.
Right, and that part I understand.
Yes.
But I'm talking about me owning it.
So
the government doesn't own it. They have right to use it.
Yes, exactly.
But I still own it because I developed it.
That's correct. And
even though I developed it with their money?
Even though you developed it with their money. And so if you are one savvy strategy that businesses employ is they look at research opportunities that they think might have commercial implication.
Right.
Go get a development contract so the government pays for the development of this item. And a COVID test is a good example because it definitely has commercial applications. So yes, the government might get someone else to supply it to the federal government, but then you get to supply it to the rest of the world and you still own it as against everybody else.
Okay.
So, and you haven't had to sink that development cost that you would have had to if you were just simply a commercial vendor.
So what if I develop my product with the government's money, they have the right to use it, but I change one or two things that don't dilute the product, but it's no longer that same product anymore? So
that's a complicated question because it depends on how much you change it.
Okay.
If that's your strategy, you should definitely go see an attorney who can guide you through those waters.
Government, I'm just talking here, okay?
But yes, that's not uncommon that happens, but you just need guidance.
Okay. And so what other aspects of government contracting and intellectual property should we be aware of, if any?
So one of the other ones is particularly for software companies. And it's again, the ownership and license right split, because depending on the agency that you're working with, different agencies have regulations that are sometimes a little bit different. But typically, if the government either pays for the development of the software, similar to the patent situation, or the software is a deliverable in a contract. So sometimes a company is not contracted to build software, but they have to build software as a part of what they're contracted to do. And that software that they build is a deliverable. Well, even if in that circumstance, the government still will get strong rights to recreate that software.
To recreate the software.
Exactly. To have, to have others, because the government doesn't do it itself,
Of
but
course,
to have
of
others
course.
do it. And so when you're setting up these contracts and negotiating them and fulfilling them, it's important to have guidance along the way so that you can set up your program in a way to maximize your own rights, and I guess not maximize the government's rights. And there are steps that you can take along the way to help that happen.
Wow. When we're negotiating government contracts, we're so interested in winning the contract and getting it done that there's so many aspects of it that we probably don't consider that we should consider. And so it's probably advisable when a company that has the potential to develop intellectual property, before they sign that contract, go see an attorney or involve their attorney in reviewing that contract. Is that something that you would recommend?
That is something I would recommend, yes.
Okay, that's important. Folks, we're going to be right back with part 2. We're going to be talking about something extremely interesting, and we're going to get some real life examples from Fred and his firm about things that we need you to know. But most importantly, Fred just told you, if you're a government contractor, you need to be looking out for yourself. The things we just talked about, you need to be thinking about, and you need to be involving your legal counsel in every contract that you're thinking about, because you need to protect yourself, and nobody's going to protect you better than you, okay? We'll be right back. Don't go anywhere. Fred and I are going to hang out till you get back, okay? Thanks. The objective of the Wealth Zone University is to change your mind about money, to change your financial future. Hi, I'm your host, Don Maraney. In the Wealth Zone University sessions, my guests and I talk about a wide variety of business, financial, and other worldly topics. We are seeking to both educate and entertain you. We emphasize that the information and discussions are my opinion, perspectives, and ideas, and those of our guests. We in no way intend to deliver or provide financial, tax, or business advice. You should consult with your tax, accounting, financial, insurance, and legal advisors regarding the impact, application, or pertinence of any topic or opinion that we share on the Wealth Zone University. Welcome back to the Wealth Zone University, a second segment. We're going to jump right back in with Fred, and we're going to talk about some more intellectual property aspects. Fred, what are some of the, let's call it safety aspects of intellectual property that we should be talking about?
Good question, Don. Every business, when it selects a name, should do a trademark search to make sure that they're not selecting a name that another business already has as a registered trademark. Because if you do that and you find yourself on the other end of a letter asking you to rebrand, sometimes that can be quite expensive. Think about whether if you're a restaurant that's been in business for 5 years and you have a physical sign out front and you have menus and you have napkin logos and maybe you've even started branding some barbecue sauce, and all of a sudden someone says in 3 months you got to change everything. Get rid of your inventory, change your sign, do all this. And that can be avoided if you had done a search in the first place and knew that this was a name that was already out there.
So most laymen think that if they go and become enabled by the state and get their name, that protects them everywhere. My company's enabled in Maryland, and so I don't have to worry about the rest of the world because nobody can use my name. That's not actually accurate, is it?
That's one of those street legends.
Okay.
It's not accurate because there's a difference between registering your name with the state and clearing it as a trademark. Those are two different things. They're related, but they're different. And so I would advise everybody to have a trademark search done just to make sure that they are clear.
Okay. And so since that's a really big street legend that everybody thinks of, what's the difference between my enabling my name with my state and in getting the trademark clearance that you're talking about?
So the state empowers you to operate under a particular name.
Just in that jurisdiction?
In that jurisdiction, right. And it is not necessarily saying that you can promote that name. So for example, some businesses, they may be registered as XYZ Inc.,
Mm-hmm.
but the sign outside the door might say something completely different because they're doing business as another thing.
Right.
So what you've done by registering that name with the state is saying XYZ Inc. is my corporation, and I'm allowed to call it that, but I may not be allowed to advertise as that if there's a trademark out there.
Oh,
That's the simple
okay.
answer.
Okay, all right. So then when I enable my entity, is it 2 steps, enabling and then trademark search?
Yes.
Or trademark search first and then enabling?
Well, it may be trademark search first because you may decide if I can't use it as a trademark, I don't want to call it that.
Uh-huh.
So if that's your calculus, then I would say the trademarks, they really go hand in hand. They really go hand in hand.
But it's prudent because since we think we don't know about it, to do the research first to make sure that whatever name you pick, you can.
Yes.
And so does the trademark search check out the entire United States?
It can, or it could check out the entire world.
Really? Okay.
Indeed, if you intend your business to be international, and I for one have clients who are international, and some of them don't select a trademark unless they can use it in multiple countries.
And so one of the conceptions is that if I enable my name in my state, that someone else can go to the next state and use the exact same name. Is that accurate?
So what can happen is they can register with the next state, but they may not be able to advertise it if you've registered a trademark. So they could call themselves XYZ Inc. They can incorporate in Pennsylvania as XYZ Inc. But maybe, depending on what kind of work they do, if they're competitive to you and you have a registration, they can't use their name to advertise their services or products.
All right. And so that's the really important part because advertising is market share, advertising is revenue. Exactly. So what other safety things should we be thinking about as a business?
So another really important safety thing is where a business obtains content and how they use it. You know, in this day and age of right click and paste, we all go to the internet, we find photographs, we find text, we find all sorts of things we want to use, and because it's so easy to get it, we think it's free. The problem is, it probably isn't. It's probably protected by copyright by somebody. And, you know, so when you're content creating, you want to make sure that you have clearance to use the content that you've sourced from another place to the best of your ability. And really quickly, you know, there's an example in a lawsuit that I'm working on right now, in fact, today, where a clothing designer apparently went on the internet and found a logo that he liked, and he took and put it on hats and hoodies and other products. Now, apparently he didn't do any searching, and come to find out that my client saw one of these clothing items in a Foot Locker, and you know, called me and said, "Hey, this is my logo. How did this happen?" And one thing led to another because the content creator did not really want to recognize my client's intellectual property, in this case, a copyright. We ended up in a lawsuit, and you know, my client was awarded significant damages because of this. And had the creator simply either done a search or, once approached, treated the situation differently, respected my client's intellectual property, we wouldn't be there. But that's not what happened, and so we found ourselves in a federal lawsuit.
Wow. So we go online all the time and take pictures and just stick it on whatever we're doing. that we shouldn't be doing, or we should be doing something before we use that picture and publicize it?
So I don't want to sound like Chicken Little. There's a theoretic risk that when you take it and use it that way, that can be a technical copyright infringement because you don't have permission to use this image. Now, most of the time, or oftentimes, you're not able to find the original creator. There are some practical issues with that. And so we have to use some judgment. But if you are doing something that is revenue generating, I mean, if you're making a product and you're going to take that picture and put on that product and sell millions of that product, that's not a good idea. Okay. Because you're raising your profile. If you just put it on a single email that you send to somebody,
not a problem.
Not a problem.
Right.
But if it's going to be part of your front-facing commercial presence, you should definitely make sure that that's cleared.
Okay. Now everything is AI now. You know, AI is writing everything. Now, is there any concerns that we should have with using things that come off of AI? And
so the AI question is ever evolving. You know, I was at a conference not long ago where they were talking about AI created artwork and whether or not there's any protection in artwork created by AI. The early answer is no, but that's still an evolving question. But if you ask AI to do something and AI pulls the content, already created content from another place, and you take and use it, there is no defense that it was AI that gave it to me. There's no defense in that area. So you still got to clear the content that you use. Okay.
So I'm still exposed.
You're still
because
exposed.
I use it. Okay.
Absolutely.
That's important, folks. Remember that. Go ahead, Fred.
I'm sorry. Copyright infringement is what we call a strict liability law. So if you got it, saying I got it from someplace else is not really an excuse. It's kind of like your children when you go in their room and catch them with something they're not supposed to have. Little Johnny gave it to me, but that we don't want to hear that, right?
Wow. And you know, with AI blowing up and we all think that everything we get off the internet is free to use. I mean, that again, more street legends. So we actually have to be more diligent about the things that we think we know about, especially when it comes to intellectual property, both business and personal.
Oh, absolutely. I mean, to give you a sense of scale, in the case that I told you about, this clothing designer probably could have done a $200 search, and he ended up having to pay $100,000 in damages. Wow. Because so these things can be quite expensive.
Quite expensive.
Quite expensive.
Fred, thank you, man. Thank you for your acumen and your expertise. Thank you for sharing it with our WZUers, CEOs, business people, ordinary people. Understand that what we think we know can be extremely dangerous. And so it may never happen to you, but when it does happen to you, it could cost you a lot of money. And so it's best to then make sure that you get the advice up front. So Fred, thank you for sharing with our audience. And I'm looking forward to doing some more great things with you and educating some folks. Okay, buddy? Thank you. For you, we'll talk to you really, really soon. Remember, you are CEO. This is your show. We're trying to make sure that we advocate and bring to you everything that you need to know in terms of proven business practices, and that you know that you have to make your business an economic asset and build in positive cash flow so we can attain that long-term goal, which is, I don't hear you, wealth. Exactly right. We'll see you soon on our next episode of the Wealth Zone University. Bye.